Want to just call it? Good morning, Ms. Lovell.
Good morning, Your Honors. Amanda Lovell for the Commonwealth. May it please the Court. The defendant in this case, there are important issues raised in this case, very similar to those that were raised in the case that the Court just heard. The most important thing to focus on regarding the outcome of this particular case is that this defendant never asked for any particular instruction regarding intoxication and force. Attorney Witkin made some sort of generalized conversational, you're going to talk about this sort of thing, Your Honor. But he filed 7 pages of written instructions. Nowhere in them was a specific request regarding this instruction.
But there was a lot of conversation, yeah.
There was conversation, yes.
But
even then, there was no specific instruction requested. He asked for the judge to talk about levels of intoxication. And I'm paraphrasing. I don't have exactly what he said written in front of me. But it was Your Honor, you're going to tell the jury that that there can be different levels of drunkenness. Isn't that right? Or something to that effect, and I'm sure my brother will be able to quote it and get precisely what it is, and it's certainly quoted in my brief.
Well, the court goes on and says in this little sidebar, if a person is so drunk they're not capable of consenting, the jury, can consider that on the issue.
Correct.
They have to make that finding as to whether she was drunk, and if so, what degree of drunkenness or stupefaction or helplessness was there, and that's solely for the jury. I'll just going to tell them what the law is on that.
Exactly, and that is what she told them. The instruction that was given is, if by reason of intoxication or drunkenness, and then those other things, a person is incapable of consenting, then the consent is without valid consent. Now, at the appeals court, and the brief that my brother originally filed in this court, but I understand has been withdrawn now, and is only relying on the most recently filed brief. At the appeals court, he specifically said that the language, the wholly insensible language from Mollet and Burke was required, and that it was error to not give that. Of course, he never requested that before the appeals court, and now he's again not requesting it. Quoting from his brief on page 21, the most recently filed brief, he says, the jury must determine whether the complaining witness's degree of intoxication was such that it rendered her incapable of consenting to sex. And that's just what this instruction does. It says, if by reason of intoxication the person is incapable of consenting, then the act is without valid consent, and the force is only that force which is necessary.
So does the Commonwealth have to prove beyond a reasonable doubt that the victim had the capacity to consent?
I would say that as a general matter, that would fall. Your Honors, in the last argument, brought up the question of insanity. As a general matter, sanity can be presumed. As a general matter, people can be presumed.
That's because of access. The defendant doesn't have to submit to an examination if he doesn't want to. And the Commonwealth has the burden of proof. That's why we have the presumption. But here, the victim's there. She can be examined by a psychologist of the defendant's choosing.
Well, I would say that the court has never held that a victim could be examined.
Well, that's because you've never argued that the victim's capacity to consent to rape was an issue.
Well,
It's never been argued in this Commonwealth.
Given the number of cases that have been decided on this issue, I'm not sure that.
The question has always been consent, not capacity to consent.
Well, I mean, I don't know. I haven't gone back and read the briefs or the transcripts in, for example, Helfand. But certainly this court, the issue was once the defendant had drugged the victim with Valium, was she able to consent?
Hey, can I ask you a couple questions? The appeals court said the wholly insensible instruction should have been given. Isn't the instruction that was given straight out of Commonwealth versus Moran that we
Yes.
approved a few years ago?
Yes, it is.
It's identical. So if it was wrong in Moran, it's wrong here, and if it's right in Moran, it's right. It's correct here.
I would agree with that,
But
yes.
but we did not approve that instruction in Moran. That wasn't the issue. The issue is whether an instruction should have been given on the subject, not whether that was the correct instruction. That instruction's in a footnote. Just by the way, this was the instruction given.
As I
It
recall,
said the judge did not err.
exactly. I've read that section.
The issue raised was whether that any instruction on that subject should have been given, and we said there was sufficient evidence to warrant such an instruction. It was not challenged as to whether or not it was an adequate instruction on the question of intoxication, was it?
Well, it was in this sense that we were deciding issues that would likely arise again at trial at that part of the opinion. And we said, contrary to the defendant's contention, the judge did not err in instructing on the relationship between intoxication and consent, and then set forth what that instruction was. Well, if we're addressing issues that are likely to arise again at trial, I think we're telling the trial judge, go right ahead and give this instruction again.
That's certainly what I understand.
But the
when-
issue was not whether or not that instruction accurately reflected our law. The question was simply whether or not the judge erred in giving the instruction first time around, and we said, no, he didn't err because there was evidence to support it. How can we take that as a affirmation by this court that that is the accurate instruction?
I'm actually, I'm trying to go
That
back
is an
into
adequate
the,
instruction on the facts of this case?
I'm actually looking at the Moran brief.
But
The judge determined to give, I'm actually reading page 23 of the brief that was filed in Moran in this court, and it's the brief that was filed by the defendant. It is an impounded brief. I obviously won't refer to any names that were used in that case. The judge determined to give the Superior Court model instruction on consent rather than the version requested by the defendants. Counsel for O'Connor objected to the judge's refusal to give an instruction that unexpressed misgivings in the mind of the complainant inconsistent with her words and actions were not sufficient to prove consent. So it's certainly, let's see, the judge reserved for the next day a decision on whether to, the judge reserved for the next day a decision on whether to give an instruction concerning the effect of sleep, unconsciousness, drunkenness, or stupefaction on consent. The defendants objected to giving this instruction at all because there was insufficient evidence that the complainant had the condition encompassed by the instruction. The judge rejected the defendant's proposed wording, which further clarified that the complainant had to be rendered wholly insensible so as to be incapable of consenting. The judge also reserved a ruling on a request for an instruction on the defense of a good faith, reasonable belief in consent. So to the extent that the decision was, the appeals court decision in this case, which said that the instruction without the wholly insensible language was in error, then I would say yes, that was clearly presented to this court in Moran.
Well, I don't read our opinion that way, but
Well, I'm reading from the defendant's brief.
I'm reading from the opinion. Both the Commonwealth and the defendant introduced evidence that the complainant had consumed alcohol in the hours preceding. There was also evidence that the complainant had taken Percocet, et cetera, et cetera. Therefore, the instruction was appropriate to give an instruction on that subject. You're saying the court that this instruction was challenged.
Yes.
The adequacy of it.
Yes.
And that we decided that point.
Yes, that's what I'm saying from having read the Moran brief.
Okay.
Yes. Yes.
And we discussed Burke and all of those cases in there and how this differed from Burke?
Your Honor,
No, we didn't, of course not, because it wasn't before the court in that sense. Or
well, the
certainly
wholly
opinion-
insensible language certainly was raised by the defendant. Whether this court, for whatever reason, decided that that was not an issue to focus on, it is certainly beyond my purview. But I would say it clearly was raised.
If we do decide, and I'm not saying we would, but if we decide that we dealt with it in Burke, then this case is over, or Moran rather, this case is over with.
Yes, I would
now,
agree with
we may
that.
for the future say, you're better off with the wholly insensible thing and not with the Moran thing, but this judge followed what she thought was appropriate language from Moran.
Yes, I think that that's a fair.
There's also ensconced, and you tell me, the Superior Court model instructions of some sort?
That's what I understand, yes. That's what I found when I was researching this.
Oh, is the instruction an accurate statement of our law?
Well, that depends on what the wholly insensible language means. I would urge the court, for the very reasons that arose in the Blanchet case, to not advise that the wholly insensible language be used, because people don't know what it means. And if I may go back again in the Blanchet case.
But what's the language you suggest?
I suggest that the language that's in Moran, that jurors understand intoxication. This is not an exotic concept to them. Jurors understand ability to consent. That is not an exotic concept. Jurors know from personal experience that people can have some level of alcohol in their systems and refuse to consent, because most people in their lives have either been in a situation where someone has made an offer to them, perhaps of a romantic nature, perhaps of some other kind of nature, or seen it happen where after having had a drink or two drinks or some number of drinks, they can still say, no, I don't want to be involved in that.
You like the Moran language?
Yes, I think that's clear. I think it uses language that 21st century jurors understand, unlike the wholly insensible.
Why isn't the language that the defendant has argued in his brief more appropriate, which blocks this out? Instead of putting this, if you find sleep, intoxication, stupefaction, unconscious, so as the complainant's incapable of consent, then you don't have to find force. Why isn't an instruction that intoxication, you must first determine the level of intoxication, you must then determine whether that level made this person incapable of giving their consent? Why isn't that block it out in a correct way, as opposed to glumping it up with sleeping and unconsciousness and all kinds of other states that obviously fall into that category?
Well, I would actually, if it's clearer to break it into two sections than one long sentence, I certainly would have no disagreement with that. But I would disagree on the point that those other things are all or nothing concepts. And I would refer to this court's decision very recently in Soulevers, where in an alternative argument, that was the fraud case where the Commonwealth asked you to reverse Goldenberg. And in an alternative argument, you note in a footnote that the Commonwealth said, alternatively, the jury could have found that because this victim was asleep during this part of this incident, she was unable to consent.
Oh, sure. I think all we're suggesting is if we do decide to go the route you want, if the case is solely about drinking, which this case is and the other case was, that we don't mention these other things. The judge just say, if by reason of intoxication a person is incapable of consenting.
Well,
you don't muck it up with sleeping and...
that wasn't what I understood Justice Cordy to be asking. I understood that it was a sort of a two-part question.
That was basically my
that's what
question.
he's
Why are we
talking.
lumping it in with all these other things, creating obvious or at least potential jury confusion? Why shouldn't we separate out and talk about the two things, not just whether or not the person was intoxicated, but the level of intoxication and whether that level made the person incapable of consenting?
Well, my only concern there is in a case like the one before you right now, where there are multiples of those factors. Caroline Ferris, who testified for the defendant, was called for the defendant, testified that the victim was helpless just before she got into the car, that she actually had to be helped to the car.
By reason
of intoxication. Yes, that's true. But it's also the case that and again, helpless immediately afterwards. It's also the case that the victim testified that she was asleep in the back of the car when the defendant opened the door and basically opened the door and forced his penis into her mouth.
But evidence of a whole bunch of things here.
Exactly, and these are interrelated things.
And of course, in other cases...
Did you argue that she was asleep? Was that your closing argument? She was actually asleep during all this?
The closing argument was this was a forcible rape. That's
right.
One of the ironies in this case, is that this was not, that the defendant argued that she was the sexual aggressor. Consent was not really an issue, of course, consent is always an issue, but that it was clear that she was the moving party, so to speak. She was the aggressor, she was the initiator. The Commonwealth argued that this was a forcible rape, and it introduced evidence of an injury on her posterior fourchette, and it had medical evidence about that, and it had...
In many drunkenness cases, you've got someone who's passed out or become asleep.
Exactly.
And you've also got drugs involved. We had that in the last case.
Yes.
So you might have to put that in, too.
And so that's why, Your Honor, I'm not sure that, and certainly there shouldn't be, it would be fine for a judge to examine the instruction and take out anything that clearly wasn't supported by the evidence.
Better instruction might be, or the better advice might be, based on the facts of the case, tailor the instruction to what factors might apply.
Yes.
You don't,
That would not be a problem at all.
You
Why
don't-
using wholly insensible?
Excuse me?
Without using the words wholly insensible.
Exactly.
but isn't there a risk, as the appeals court found, that one might, sorry, is this allowed? That one might equate intoxication with being incapable of consent, the way this is phrased?
I don't believe so, Your Honor. And in thinking about that, I tried to come up with an analogy. If a jury were trying to determine negligence in a motor vehicle case, and the instruction was, if by reason of speed a person cannot stop the car he's driving, you may find that he was reckless. I think that clearly tells a jury, you have to figure out, it's not going to say if there was any speed, then...
Yeah, but if the speedometer says 20 miles an hour and you're in a 25-mile-an-hour zone, and you are actually going 50 miles an hour, doesn't the person driving the car get to rely on a mistake of fact in that situation?
Well, that may be the case, and if I can come back to that in just a second, Your Honor. But to, I think, more fully answer your question, if one adds in something else, like if by reason of speed or knowing gross malfunction of vehicle, the defendant is unable to stop, you can find that he's reckless. That doesn't mean that, even if the knowing that there's a gross malfunction is sort of more an all or nothing proposition. That doesn't
so
make
the defendant,
a speed.
there's a mistake of fact defense, is that you seem to be conceding, or you
Well,
have to concede.
I actually, at the same time that Justice Graney asked the question about Burke in the last argument, I was reading the language in Burke.
Yeah,
and
it
I
says
think,
as he knows.
And I think that pairing that with the language that is pairing that with jurors understand intoxication, jurors understand consent, that perhaps this is an area.
But what about jurors understanding that people have different reactions to alcohol? How do you deal with that?
Well, the victim actually in this case attempted to testify that because of her ethnicity, that she's Asian, that she has a different, or that many Asians have a different reaction to alcohol. She wasn't permitted to do that. I would suggest that would be appropriate testimony, perhaps in a case like this. I would also say that...
Is the defendant supposed to know that?
This defendant was a dentist. And so whether he specifically knew about whether Asians have that connection, I would argue that that's a not uncommonly known fact in the general public, and therefore in the among medical professionals. He could have been asked that if she had been able to testify about it. This defendant testified, he could have been asked. This defendant was asked whether in his professional medical responsibilities it wasn't important for him to be able to know when someone is intoxicated, and he said yes. And there was a discussion about because you wouldn't perform certain dental procedures on a person if they were intoxicated, it would be dangerous for that person. So in this
but
case...
they could consent to the procedure, even if they were intoxicated.
That could be, but what we have here is a case with an individual who, more than the average individual, would be in a capacity to understand the relationship between intoxication and to be able to recognize intoxication. He also, by the way, described this victim as drunk and intoxicated and buzzed. Frequently he said buzzed. And I just want to very quickly mention that the alternate ground that the appeals court reversed the case on was suggesting that the colloquy between defense counsel and Judge Donovan, where she allegedly said she was going to...
So is intoxicated a .10?
In this case, there was no evidence about...
is intoxicated a .10?
I wouldn't be able to answer that question, and I actually think
Could
that...
not be.
Yes, I think there was... I think the fact of having jurors make these decisions makes sense because the jurors are more closely in the position that an individual is when they're trying to determine...
What kind of guidance are we supposed to give them as to, or should a trial judge give a juror as to what level of intoxication rises to the level of completely dissipating consent, the ability to consent.
Well, I think that's a thing that's known to the common individual.
Well, then tell me
the
what
common
it
juror.
is, if it's so easy to understand, if it's in
Well-
everybody's ken, because I don't, help me out.
Well, I would say in the same way that we tell jurors to look at all the factors when trying to decide whether the defendant, whether his intoxication affected his ability or his having committed a crime with deliberate premeditation or with extreme atrocity or cruelty. We say you can look at all the factors, and intoxication is one of them if there's evidence of intoxication. I think that what we're saying is jurors understand intoxication. Is it easy to define? Can I go back to the Webster language? Maybe I can't give the court any better instruction than what is in the model instructions. But I can say that.
Or in Burke.
Well, except for that wholly insensible language, which
Why is that no good?
that may have made lots of sense when it was written in Burke.
I mean, that's where our instruction comes from. That's the root.
Understood, but in a 1997 dictionary that I quoted in my FAR application to this court, the insensible is defined as having lost consciousness, especially temporarily unconscious, one that didn't appear to apply here at all, devoid of physical sensation or the power to react as to pain or cold, which, by the way, what this victim testified to was that she would qualify for the defendant's definition from the last case, where she was physically unable to say no and physically unable to resist. She was one step short of unconscious. Defendant made a completely different argument, but clearly...
Whatever the use of the language, and I understand that we're doing that here, the one thing that Burke makes clear, because it uses wholly insensible, utter stupefaction, Burke is signaling essentially somebody who is, absolutely incapable of giving her consent, correct?
Then perhaps the word absolutely incapable. I mean, absolutely is a word that's understandable.
Utter? In any event, your
Yes.
time is way over. But
I understand that. I do just want to say the last thing
No,
was
I'm
indifferent is the last definition of wholly insensible.
Thank you, Ms. Noble.
Thank you, Your Honors.
If it pleases the
Bailey.
court, Brad Bailey on behalf of Martin Urban. Before I start, I just want to point out one thing in response to something that Justice Graney said. If this court does find that the law is as stated as Moran, which I clearly and respectfully submit, that's not what this court said. I don't think this case is over, because the second part of my argument is the 2 times clearly signaled instruction that was relied upon to the detriment of the defendant was given, and Commonwealth versus Senna says that that's an independent grounds for a reversal, as the Court of Appeals recognized. But Justice Cordy raised the Moran case, Your Honors, and I agree. Having read that over and over again, because that clearly is a case that to get where we are, we have to analyze and examine. I don't see that as this court saying that is the law on intoxication and consent. Indeed, it simply says in a footnote, this is the instruction that was given. What this court, as I read...
Did it say the judge did not err in giving the instruction?
It did not err in giving an instruction, and this court makes clear to point out the relationship between intoxication and consent. That's what the decision says, and there is no question that that's what needs to be done in cases with intoxication and consent. You do need to point out that there is a relationship, and what's instructive in Moran is defense counsel didn't want any instruction whatsoever, did not think it applied. And this court said, no, you need to give an instruction when you have those. Also, Moran had a wholly insensible complaining witness, which was not the case in Urban. But I think the applicability of Moran is just that. Instructions to the courts give some form of instruction about intoxication. and
Have you
consent.
checked on how other states formulate their instruction on on this kind of thing?
I did not, Your Honor, for purposes of this case, because frankly, in my opinion, if you go all the way back to Burke and then forward, Burke, Ascolillo, as this court did, Mawley, Simcock, and as we think was correctly done in Urban, we're looking at degrees of intoxication. That's what those cases say. So when we get to the model instruction, it's our position that that's clear error because it doesn't instruct as to degrees of intoxication. It's
You're dealing with a jury here. They've all been drunk one time or another. They understand what the different levels of intoxication are. And you're saying it's got to be drunk to the point where you can't consent.
yes, but look at Burke in 1870 and whether or not wholly insensible applied to this case. We're setting aside. Burke doesn't just say if intoxicated. Burke says if stupefied as a result of intoxication.
Because it was Victorian times, and that's the way they talked.
It may have been the way
We
they
don't talk that way anymore.
It may have been the way they talked, but it doesn't have a comma between stupefied and intoxicated as the model instruction has. And so even back then, the SJC got it right with all their archaic language. Let's go to the model instruction. Yes.
But wait, yeah, well, that was what I was going to ask you. Is your argument or part of your argument that by putting intoxication in the same line as sleep, unconsciousness, helplessness, which are sort of all or nothing propositions, that if someone is that the danger is if someone is intoxicated at any level, then one might assume they are incapable of consent?
Absolutely, Your Honor. That's what I'm saying. And in fact, whether it's fair or not to do this,
Well, there's different levels of sleep, too, correct? Different levels of sleep.
understood. But nobody here is saying that if somebody's asleep, they're going to consent to sexual relations occurring during the time that they're asleep. But going to the model instruction, if it's fair to do it, and I think this is, let's just put numbers in front of each state of being consciousness that they do. And listen to the instruction carefully. It says, if by reason of 1, sleep, 2, intoxication, 3, drunkenness, 4, stupefaction, 5, unconsciousness, or 6, helplessness. That's not the law of the Commonwealth of Massachusetts. Again, let's go back to Burke where it says stupefaction or stupefaction, not sure which the word is, caused by drunkenness. This instruction misleads and confuses. And, Your Honor, when you say, well, jurors have all been drunk, this is a life felony. In misdemeanor OUI cases, we talk about .01. We give guidance to the juries when the maximum potential sentence is 2.5 years. We don't just assume they all know it when they say it.
Says drunk or intoxicated, either one, to the point where they can't give consent. There's the definition for the jury.
I don't believe it says that because I think the drafters of the model instruction compound it by then saying sexual relations during such incapacity, and the incapacity goes back and qualifies the drunkenness and intoxication. And it completely misleads the jury to the conclusion that intoxication itself disqualifies consent. And, Your Honors, the colloquy that's at issue in this case that I talk about in the twice signaled instruction, that's all predicated on the judge first mistakenly saying intoxicated people can't mistake. Now, if you can't consent. Now, if you have an experienced jurist saying that out of the box, imagine what's happening to jurors. And even this court in the Coltori case
So if the judge had given wholly insensible that instruction, you wouldn't be here.
If the judge had...
You don't support what these people said in the case before you.
Well, I am absolutely not taking the position that wholly insensible is not the law of this Commonwealth, and we certainly have pointed out that we agree that wholly insensible people cannot consent.
Well, how would you formulate an instruction that's both doesn't use wholly insensible yet complies with your theory of levels of intoxication? What would you say? And
also, I think that's important, Your Honors, because I think that, I don't know whether a trap is the right word, but I also don't want this court to be seen as saying, it's open season on anybody who's not wholly insensible. So it's delicate, but I also don't think the model instruction is right. In the first trial, as we indicated in our brief, the trial court said, on the issue of drunkenness or intoxication, it is for you to determine whether or not the complaining witness was to the point of being unable to consent and what her level of intoxication or drunkenness was. I think that hits Burke. I think it hits this court's ruling in Ascolillo, where it talks about state of intoxication, not intoxication. I think it hits this court's, the Court of Appeals ruling in Mawley and in Simcock, where it says degree of intoxication.
So if the word state of had been put in front of drunkenness, that would have been okay here?
I think it's clear that this court has been edging towards a two-tier analysis. Intoxication, and if intoxicated, how intoxicated, if so much as to be unable to consent. And I think it's important to note that when that instruction was given, there was a hung jury. And as this court pointed out in the Giguere decision, if I'm pronouncing that right, the adequacy of jury instructions must be determined in light of the overall impact on the jury. When that was given, they really couldn't agree on whether or not a rape had occurred. When the model instruction was given, the defendant was convicted. And I urge the court to view it.
So your instruction would be it's for you jurors to determine the level of the complainant's intoxication. Apparently, I may have to tidy this up. And once you've determined that, whether it reached a state of intoxication that rendered her incapable of consenting.
That's correct, Your Honor. Or, frankly, as in her colloquy.
Maybe all right, because there are levels all the way from, got a buzz on to tipsy to flat out drunk.
That's exactly right, and that's what's important to note in this case. We have wholly insensible, and I think we all do know wholly insensible. But there has got to be a practical instruction for buzzed, drunk, or maybe even very drunk, as trial counsel said.
Don't define the levels. That's for the lawyers to bring out in the evidence and argue to the jury.
Absolutely, and that will go to my second piece in a moment. But I do want to talk about the specific intent argument that has been raised by the Commonwealth in saying that in negating specific intent, intoxication, the issue of intoxication is brought up. This court has never said, plain and simple, intoxication alone. In fact, in the Eric Brown case, you just recently said disabling intoxication. Again, even there, you're giving guidance on a degree of intoxication. The model instruction just doesn't do it. It lumps it all together with this sleep, unconscious, and it doesn't give any guidance to the jury, as the trial court suggested she was going to do, in which she said...
There's a little evidence about sleep and a little evidence about drugs and evidence about alcohol. You've got to put all three in there, don't you? I mean, suppose, as typically happens in many of these cases, they have a little cocaine or marijuana, then they go down to the bar and have, a lot of drinks, and then they're in the back of the car and they semi-pass out, fall asleep. Wouldn't all of that have to be put in?
Well, Your Honor, we're in this instance addressing a case where somebody is walking, talking, perceiving, recollecting. In fact, in this...
Mr. Bailey, let me ask you this. Our jurisprudence derives from, common law, and I mean, they have the same issues in other common law countries. I think I may be correct, but I may not be correct, that the English term is state of unconsciousness. In other words, it doesn't matter what the cause is, whether it's sleep or alcohol or drugs. It's a state of unconsciousness.
It's a better word.
And so you couldn't be in a state of unconsciousness if you were walking, talking, whatever it is. Sometimes, and it seemed to me that at least that we're getting very hung up on whether, sometimes sleep is not a state of unconsciousness in the sense that a very small interference will awake you. Other times, particularly if you've had alcohol and drugs or sleeping pills or Percocet or, whatever the facts are, it's a state of unconsciousness. I think isn't that the concept?
Well,
behind Burke and those cases that...
Well, the concept behind Burke is stupefaction caused by alcohol.
I understand that, but that happened to be an alcohol case, and there was big discussion in that case about whether it did or didn't make a difference if the defendant gave the alcohol in order to bring it. But I think when you use the words like stupefaction, in other words, if there was unquestionable evidence that the complainant was in a state of unconsciousness at the time, it surely wouldn't make any difference if that were caused by alcohol or caused by Percocet. In other words, it seems to me we're going in through the wrong door, at least arguably going through the wrong door, because that invites precisely the kind of inquiry that Justice Spina has suggested, and in fact you yourself has suggested, which is how much alcohol? Well, it depends. The question is, was the complainant in a state of unconsciousness or utterly stupefied?
And that may well be, Your Honor, but if that was the case, then certainly you're looking at a substantial risk of a miscarriage of justice, that the wholly and sensible language was neither asked for nor given in this case. And I'm saying that I think it wasn't given because for whatever reason the evidence probably didn't suggest that. And if we're dealing with those, not the extreme cases of the state of unconsciousness, but everything else in between, that model instruction just doesn't get us there, and it completely confuses and misleads because it puts that comma after intoxication and puts that comma after drunkenness and does not tell the jury in a life felony case that intoxicated people can be capable of consenting. And if that's upheld, Your Honors, imagine what's going to happen in every college handbook. Imagine what the law... I don't think this court wants to go there, where there's going to be interpretations, as the amicus brief suggests, where if you're intoxicated, you can't consent. And if we uphold the model instruction as it's written, I respectfully submit that's what's going to happen. And I know I'm out of time, but I certainly do want to go to that Commonwealth versus SJC twice clearly signaled instruction that was never given.
Well, you are out of time.
I know, but we let Ms. Lovell go for another 5 minutes, so why don't you make a short point, if you can?
I think it speaks for itself. Not only does the judge make a misstatement of the law that causes counsel to get right up there and say, Judge, you're not saying that intoxicated people can't consent. And she says, no, this is what I'm going to say, that of course they can in their degrees. And she gets it right. She says it as I urge this court to find the law should be. And he says, okay, so that's what you're going to give. And she says, basically. And he concedes the whole issue. Jumps right up and says, no question she was drunk. Doesn't argue back and forth. Doesn't reiterate facts that could have shown she wasn't drunk. The instruction then is given... The instruction then given is a model instruction. And he gets right back up there again and says, Judge, you said you were going to talk about degrees of intoxication. And she says, obviously, I will tell them that intoxicated people are capable of consenting. And then she doesn't give it again. and I think the Court of Appeals could not have said it more eloquently. She induced trial counsel or the defendant to place his head in the proverbial mouth of the lion, and in that detriment, completely prejudiced the defendant by not giving the instruction that she said she was going to give and then reiterated that she was going to give. So for those reasons, we ask the Court to agree with the Court of Appeals in Urban and to set aside the verdicts in the trial court below.
You don't make any argument about mistake of fact.
Well, Your Honor, I raised it initially, and the Court of Appeals said they didn't see it on these facts. And I would be happy to invite this Court to
Do you brief it?
I briefed it originally, but we had an issue of having to file a replacement brief, and so we did not put it in our replacement brief. But it was clearly raised and argued before the Court of Appeals.
Thank you, Mr. Bailey.
Thank you, Your Honors.